Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, sir.
Mr. Nelson, in cause number 23 DCCR 1786, you're charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 23 DCCR 1787, you are also charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone.
Sure.
State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None. Sir.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the bailiff. Yes, sure.
We would ask that the court waive any court costs as he is indigent. The court needs me to inquire about that. I'm happy to, but he's been incarcerated for 2.5 years, and he has 0 dinero.
What are the typical court cost on a
$200 and something plus this fee plus that fee? So total in both cases, Your Honor, will be around $550.
What I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly what the process for that, and take into consideration that he's indigent, that you relay that, and I will let you know exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back with bailiff. Yes, sir.
Have a good day.
You'll make a note for me on that, please. Good morning, ma'am. Are you Relacia Mouton?
Yes, ma'am. Sure.
And Ms. Mouton, in cause number 25, DCCR 0907. Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there?
Did this in January 20th.
The competency reports from October.
You found her competent January 20. That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't. There's a lot of things that were,
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway. Found competent based on that report. There hasn't been any other reports that I know other than the Dr. Crapon report from back in October. And so any other issues at this point with regard to competency?
No, Your Honor.
All right, so in cause number 25, DCCR 0907, Ms. Mouton, you're charged with a second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record. Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So the second one, same thing, is a second degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25, DCCR 1468, you're charged with assault on a peace officer. And this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently. And then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
Because I just signed paperwork refusing 2 years for both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay. So you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial,
Yes, ma'am.
what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we
I
have.
understand.
So, Mr. Rojas, you're released. And Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
Judge, I thought that was a very generous offer.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is, and so there's not going to be any change just because there's a new lawyer.
I've seen the tapes, and it's not enough on the tape to show that I deserve 8 years.
All right,
I
that'll be
haven't
up to
gotten trouble in 20 years.
that'll be up to a jury. That's what juries are for. You can go back with the bailiff.
At this moment, the decision is entirely hers. The court has made sure she understands the risks, but once a plea deal is rejected, the outcome is no longer in anyone's hands except the jury's. If you're enjoying these real courtroom moments, don't forget to like and subscribe.